It's common for lawyers to include in their clients' wills a provision incorporating a written memorandum directing the disposition of their tangible personal property. This type of provision ensures the lawyer's time and the client's money aren't wasted if the client later changes how certain assets should be distributed. In the 1991 case of Clark v. Greenhalge, the Supreme Judicial Court of Massachusetts considered whether a woman's written notebook was a memorandum incorporated by reference in her will. In 1977, Helen Nesmith duly executed a will that named her cousin, Frederic Greenhalge, as the executor of her estate. Greenhalge was also identified in the will as the principal beneficiary of Nesmith's estate. Upon Nesmith's death, Greenhalge was entitled to receive all of Nesmith's tangible personal property except those items specifically designated by a memorandum. Among Nesmith's most prized possessions was a large 1833 oil painting of a farm scene, valued at $1,800. The farm scene painting, however, was never identified in Nesmith's will. Additionally, Nesmith kept a notebook in which she listed items that she wanted others to receive upon her death. In the notebook, Nesmith stated that she wanted her close friend, Virginia Clark, to have the farm scene painting. After writing the list in her notebook, Nesmith executed 2 codicils, or amendments, to her will. Nesmith's private home care nurses also stated that on several occasions Nesmith expressed to them her intention of giving the farm scene painting to Clark. Nesmith passed away in January 1986, and Greenhalge refused to deliver the farm scene painting to Clark because it interested him, and he wanted to keep it for himself. Clark then brought an action against Greenhalge as executor of Nesmith's estate in probate court, seeking to compel Greenhalge to deliver the farm scene painting to her. Greenhalge argued that the notebook couldn't be considered a memorandum because it wasn't specifically identified as a memorandum and wasn't known to him until after Nesmith's death. The probate court disagreed, concluding that the notebook was a memorandum incorporated by reference in the will. Greenhalge appealed, and the appeals court affirmed. The Supreme Judicial Court of Massachusetts granted Greenhalge's petition for further appeal.